getting them to work around that angle, because that's somewhere we are also starting to work with Dynamam Government Law College. And the idea of the course was also to get them to start thinking about it during their career and to see that that's where the future now lies. You need to start
Yeah.
thinking, break that silos and start thinking that way.
Hmm.
Uh, yeah, now they're, oh, thank you so much. Everyone's back. I mean, they're joining us. Yes, I think, ma'am, yes?
Yes.
Yes. Good afternoon, everyone, and welcome to this expert talk on climate conscious lawyering and the role of legal education. It's my privilege to be the moderator for today's session. The urgency of climate change has made it clear that law and policy must play a central role in addressing environmental crisis. As legal professionals, educators, and students, we have a responsibility to ensure that climate justice is embedded in legal education and practice. But how do we do that effectively? Today, we have it as the perfect speaker to guide us through this discussion. We are honored to have with us Associate Professor Julia Dehm, a distinguished scholar in international and domestic climate change law, environmental governance, and human rights. She is an ARC DECRA Fellow at La Trobe University, Australia, and has made significant contributions to rethinking climate law, economic justice, and legal education. Julia has authored influential works, including Reconsidering Red Players' Authority, Power, and Law in the Green Economy, and Becoming a Climate Conscious Lawyer, Climate Change and Australian Wisdom. She is also leading an important project to mainstream climate change in legal education and has worked with institutions like the UN, Princeton University, and the Harvard Law School Institute for Global Law and Policy. Today's session will explore how we can embed climate consciousness in legal training, what challenges legal educators face, and how future lawyers can be equipped to tackle the pressing climate crisis. The format of our session will be as Julia will speak for around 30 minutes, after which we will open the floor for a Q&A session. And I encourage all participants to actively engage. Feel free to note down your questions in the chat, and we will address them in the latter part of the session. Without further ado, I now welcome Associate Professor Julia Dehm to share her insights. Over to you, ma'am.
Thank you so much for having me and for this invitation to speak to you today about the work that I'm leading on the Climate Conscious Lawyers Project, together with my colleague, Professor Nicole Graham from Sydney Law School and Zoe Ney from Melbourne Law School. So our project is working to transform Australian legal education to ensure that the next generation of legal professionals have the relevant expertise and competencies to deliver legal services and promote climate justice to a wide range of clients in a climate transformed world. So I'm necessarily speaking from our Australian experiences, and a lot of the examples that I will use will be those that I'm familiar with from the Australian legal education and legal system, but I hope that what I'm saying has relevance to you in your own jurisdictions and might work as an inspiration for different ideas about how we can do this work, because I think it's really urgently important. Before continuing, I want to acknowledge the Wurundjeri people of the Kulin Nations, who are the traditional owners of the land on which I'm standing at the moment, and to recognise that this land was stolen, that their sovereignty has never been ceded, and to pay my respects to their elders past and present. So the premise of our project is that climate change is one of the defining challenges of our time, and that law plays a key role in climate change responses, including reducing emissions and enhancing sinks of greenhouse gases, adapting to the adverse effects of climate change, and providing compensation for loss and damage associated with the adverse effects of climate change. And we argue that climate change impacts and the transition to a low carbon society are already posing fundamental challenges to legal doctrines and principles and transforming many areas of law. So the widespread legal change that is necessary to grapple with the climate crisis, we argue, extends beyond a specialised field of climate law that might be taught as an elective in a law school or environment law, but instead really implicates all areas of law and legal practice. And thus, current law students will need a transformative legal education to guide them to become climate-conscious legal professionals. And thus, we think the mainstreaming of climate change considerations across the whole law degree is urgently necessary. So we can think about law and the relationship it has to climate change in a number of different ways. So, for example, some legal doctrines or areas of law might have contributed to the climate crisis and its underlying inequalities. So we could think about how law has authorised and enabled the lock-in of fossil fuel economy through property law, licensing regimes, and protecting fossil fuel companies. Alternatively, some areas of law and legal competencies might help us address climate change. We could think here particularly about the growth of climate litigation that I'll talk about more later. And again, similarly, we could recognise that legal doctrines might be impacted by climate change or the transition to a low carbon society. So, for example, there's already a lot of challenges around how insurance is going to operate. So this means that lawyers will increasingly have an obligation to adopt a climate conscious rather than a climate blind approach to daily legal practice. As the Chief Justice of the New South Wales Land Environment Court, Justice Brian Preston has argued, and I quote, "A climate conscious approach requires an active awareness of the reality of climate change and how it interacts with daily legal problems." And he's written a lot about this, and you can look up his articles. And the need for legal practice to become more climate conscious has been highlighted by a number of legal bodies internationally and in Australia. So just to give you a sample of some of these statements, this is a statement put out by the International Bar Association in 2020, which again talks about the need for a climate conscious approach to daily legal practice. The American Bar Association has put out statements in 2015 and 2019. And the Australian Law Council also has put out statements saying that, novel complex areas of law are arising and are likely to arise across multiple practice areas, and that diverse groups of Australians will also present new demands from rural, regional and remote communities to small business owners to First Nations communities. They talk about how lawyers should be alive to the unfolding implications of climate change and its consequences, and they should be informed, skilled and ready to assist clients on climate change related legal matters within their areas of skills and competencies. And they sort of said too that we assume that, the need for this change is being supported by legal education. And I think this was a bit of an assumption, but I'm glad that the work that myself and my colleagues are doing is trying to fill this gap to make sure that legal education is rising to this challenge to ensure that we are producing the type of legal graduates that can be more climate conscious legal practitioners. A few years ago, a few hundred lawyers and legal academics signed a World Lawyers Pledge on climate action, which also stressed that lawyers of all kinds, not just environmental and climate lawyers, should be asked to consider, integrate and apply issues of climate change and climate justice throughout their respective areas and activities of expertise. And increasingly, this isn't just, and here the International Bar Association's got a website where you can see all the different statements that have been put out by law societies and bar councils around the world. So there's many more statements along similar lines than the ones that I've been able to talk to you about just now. And increasingly, this isn't just sort of a question of normative aspirations of what lawyers should be aiming to do to be climate conscious, but really has increasingly is becoming a matter of professional competencies and professional obligations. For example, last year, the Law Society of New South Wales issued practitioner guidance for solicitors, which argued that there's an evolving duty of care owed by solicitors to their clients to provide advice regarding a legal problem, which meaningfully addresses any climate change issues and related consequences. And similar statements have been issued by the Law Society in the UK as well. So turning now to sort of why is it that lawyers need to think about climate change? And as I said in my opening, law can play a crucial role in mitigating and adapting to the impacts of climate change. And like while law cannot solve the climate crisis in itself, lawyers must play an important role. And there's really been a global surge in climate litigation or legal cases that address climate change mitigation or adaptation or litigate the science of climate change. That litigation going against both governmental actors and corporate actors. The UNEP's 2023 climate litigation report documented 2,180 climate litigation cases globally, and this is a growing number. More and more are being filed every day. And whilst this was initially more of a global north phenomenon with climate litigation, there's a real surge of climate litigation now in the global south, as well as scholarship looking at climate litigation in the global south. And while the sort of first generation of climate litigation relied primarily on traditional environment law methods of seeking administrative or judicial review of governmental decisions, the so-called second generation of climate litigation has become increasingly innovative and raises an increasingly broad number of causes of action, including arguments around public trust, human rights arguments, corporate law duties, fiduciary duties, consumer law or greenwashing arguments, torts, and more. And thus, in this way, it's really all these different areas of law have become both relevant to the question of climate action and are being transformed in this process by these sort of litigation practices and the court cases that come out of them. As well as driving change, I think lawyers and legal professionals have a broader obligation to consider systematically how law will influence the way in which society experiences and responds to climate change. And central to this is recognising the role that law plays in allocating risk, liability, cost, responsibility, and the equitable and distributive implications of this, of how we divide risk. And so in the past few years, there's been growing awareness of this sort of discourse of climate risks. And here I sort of take the definition proposed by the Task Force on Climate-Related Financial Disclosures, which talked both about transition risks, so legal and policy risk, technology risk, market risk, reputational risks, as well as physical risks related to the impacts of climate change, which are both acute and chronic. And these questions of climate risk might arise in contractual disputes if a contract needs to determine how risk is allocated between the different parties. A lot of law is about the obligations that specific actors have to disclose and to manage risks, such as corporate directors, fiduciary, and various fiduciaries, etc. And finally, what for me is the most important aspect is because climate change reflects and reproduces existing inequalities and vulnerabilities, it's also unavoidably an issue of equity and fairness. Climate vulnerabilities intersect with and reproduce existing marginalizations in terms of race, gender, age, with children and the elderly being most vulnerable to climate impacts, disability, and more. And thus, there are strong demands for climate justice. And again, law plays a crucial role in thinking through these justice questions. And climate justice has, as we know, multiple different aspects: distributive justice, procedural justice, recognition justice, and reparative and corrective justice. And thus, I'd stress that being a climate conscious lawyer also requires lawyers to be conscious of these intersecting justice issues raised by the impacts of climate change and the transition to a low carbon society. So to recap, we're arguing that all lawyers increasingly need to be climate conscious, and we suggest that this involves asking a number of questions in sort of daily legal work, sort of how might climate change impact different areas of law, how might different areas of law contribute to climate change's underlying inequalities, and how might different areas of law and legal competencies help us address climate change. But if we want lawyers to be climate conscious, we obviously need to transform legal education to produce more climate conscious legal professionals with the skills and knowledge to be strategic and successful advocates in a climate transformed world. And I think there's a number of different reasons why we need to make these changes in legal education. So first is sort of addressing student demand, that there's a real demand from students for more climate conscious legal education. Law students see the scale of the climate challenge and are signalling that they want to be part of the solution. A 2019 global survey of 10,000 young people aged 18 to 25 found that climate change ranked as their top most important global issue. And so students want to do something. Secondly, this sort of idea of social justice and addressing a social need. And one of the things that I keep coming back to is that our current law students will be leaders of the profession in the middle of this century in 2050, which is sort of the date that was set in the Paris Agreement when the world needs to have reached net zero. And so again, you know, the students that are going through now will really be in leadership roles at this crucial period. And then finally, you know, there's a lot of talk in climate risk discourses about the risk of assets becoming stranded. Sort of stranded assets being assets that are subject to unanticipated or premature write-downs, devaluations, or conversions to liabilities due to climate-related impacts. But I would argue like the focus has mostly been on fossil fuel reserves becoming stranded assets if they can no longer be extracted from the ground. But increasingly, I think it's worth considering whether degrees that don't equip students for a climate-transformed world are themselves becoming a type of stranded asset. So in Australia, law is a professionally accredited degree, and thus in order to be eligible for admission as a legal practitioner, students need to have completed a professionally accredited law degree, as well as practical legal training and demonstrate that you're a fit and proper person to be a lawyer. But that means that you don't need to sit a bar exam in Australia, but rather you must have completed a number of these prescribed knowledge areas or the priestly 11 subjects, which I've listed here on the slide. And so from our perspective of trying to transform legal education, this has made it kind of made us really focused on these subjects and trying to transform these subjects because they're the core compulsory subjects that every law student needs to undertake. And just to give you a bit of a flavour of how climate considerations are relevant to all these areas, I'll just talk through a couple, but obviously don't have time for all of them. So criminal law. The question about whether fossil fuel companies could be charged with homicide or other crimes is increasingly sort of coming up in sort of legal scholarship and I think increasingly in legal practice. But we've also had a massive rise of criminalisation of climate protests. And in some of those activists that have been charged have raised the defence of necessity, arguing that they're doing what they're doing to avoid a greater emergency, for example. And so I think sort of thinking about climate change in the context of criminal law really opens up broader questions about the purpose, the function, and the biases of our criminal legal system that are really interesting to explore. Company law. So this has been one of the areas of the most developments, both in Australia and around the world. So in Australia, we've had litigations, a case called Abrahams and Commonwealth of a shareholder taking a company to court regarding the disclosure of climate-related risks, and it's settled prior to judgment. But we've also had changes to the Company Law Act requiring now that companies disclose climate-related risks. And there's also been litigation talking about how directors of companies must manage climate-related risks. We've had a lot of shareholder resolutions also about challenging whether the board of a company is properly managing these climate-related risks. So this has been a real area of climate embedding. Contract law. I think some of these issues might not be as immediately apparent, but there's a growing movement by practitioners to incorporate climate-conscious contractual clauses in contractual drafting. This work is being spearheaded by the Chancery Lane project. And there's like a lot of questions there about, you know, what sort of clauses you can do, how clauses can drive the transition to a net zero society, but also broader questions about contract law, about, you know, to what extent a climate-induced natural disaster would constitute a force majeure event, for example, and what implications this has on the realisation of a contract. Another area has been professional responsibilities. And as I indicated earlier, there's been guidance from law societies in the UK and in Australia about what are professional obligations of lawyers. And we also have students being increasingly vocal on these issues. So Law Students for Climate Accountability, for example, are developing a scorecard in the US and in Australia, ranking top law firms based on how much fossil fuel work that they do. So in the interest of time, I unfortunately can't go through all these core subjects, but I hope I've given you a bit of a flavour of how climate change has become relevant to so many different areas of legal practice. But one thing I think we need to be really alert to when we're trying to do this work of climate mainstreaming is that it's not just a question of content, but also about how we deliver this material. And I think this is particularly important given the widespread prevalence of what's been called climate anxiety. And thus it's crucial that we deliver this sort of content in a way that doesn't add to student distress, but rather creates a sense of empowerment in students and supports them to feel that they can use their skills to actually make a difference to this global crisis. So we suggest in our work that there's a couple of different pathways to climate mainstreaming in legal education, which could involve both more top-down institutional approaches that you might say at a law school level, we're going to do this and sort of think about how you embed it in your curriculum across a whole degree, and then include it in assessment tasks, etc., including your subject intended learning outcomes, or sort of at the bottom here, sort of ideas about supplementing, where, you know, people might just simply, individual academics might include informal discussions with students or supplementary readings or learning activities that bring some of these climate questions in, and might be bringing a newspaper article in and saying, how does this relate to the doctrine that we've just been talking? And while there might be some institutional barriers to sort of these sort of embedding or centering approaches, we really argue this idea of supplementing is something that everyone can do relatively easily. But for all these sort of different pathways of mainstreaming, we think there's a number of prerequisites that need to be in place. One is an awareness of the need for climate mainstreaming. Two is educational resources that can be used by academics in climate mainstreaming. And thirdly is networks of peer support to support each other in that process of climate mainstreaming. And thus our project has three interrelated and mutually supporting elements. We're trying to map pedagogical change, we're developing educational resources, and we're trying to build a community of practice to promote the resources and support the shift to climate conscious legal education. So I'll quickly talk through some of that work. So in order to map pedagogical change, we conducted a survey of Australian law academics in September, October 2023. And it showed us, so you can see here, like in a lot of subjects, I mean, the responses weren't huge, but we had about 10% of law academics in Australia responding. There is obviously a bit of selection bias that those who respond are those who are more likely to be doing this sort of work in mainstreaming. But you can see that for a lot of subjects, a high proportion of lecturers were already doing some of this work of climate mainstreaming. And we're currently in the process of writing up this material for an article. But again, the survey also asked about what are the barriers that people are experiencing, and they were what we expected. Lack of resources, lack of knowledge about the climate legal practice, and lack of knowledge about what best practice in mainstreaming pedagogies is. And the survey thus sort of reinforced our assumption that what was needed was access to resources and being part of a community of practice to overcome these barriers. And so one of the exciting parts of our project has been that we've been really working on developing an open access textbook titled Becoming a Climate Conscious Lawyer, Climate Change in the Australian Legal System. And this textbook provides an original, innovative and accessible analysis of the impact of climate change on legal doctrines and principles, and tries to analyse cutting-edge developments and how the transition to a low-carbon society is reshaping a whole range of different laws. So the textbook as a whole will have 26 different chapters. We've got 45 different authors who are legal educators or legal professionals from 15 law schools in Australia. And we'll have a chapter on each of those compulsory core subjects that I mentioned before, as well as a number of different popular electives. And it'll be published in 4 different tranches. So we want to get the chapters that are finished out as quickly as possible, and some are still in progress. We published the first tranche of 3 chapters in July last year. Just yesterday, we published our second tranche of another 7 chapters, and we've got some more chapters in the works that we'll publish later this year. And one thing that I'm really excited about is that this book is open access, published through the La Trobe e-Bureau. And this means both that it's free and available for everyone to access. We don't have these financial barriers to access educational resources, but also because it's all online, it allows us to embed multimedia content, allows us to hyperlink to judgments, to other resources that students might want to access, and really allows for a much more interactive learning experience. The other thing that's really great about the online format is that this area of law is changing so rapidly, and so there's often need to do updates, and this online format allows us to do updates if there's been a new case or a new legal development, much easier than sort of a traditional print format. We've also trying to build a community of practice to promote these resources, including by hosting national and international workshops and conferences. We've developed a website, which you can have a look at. And these sort of, yeah. And then the other thing, the project keeps expanding. So our close work with the librarians and the open educational resource professionals has led to the expansion, and we're now also developing a educator's companion, which is more directed not to students but to legal educators, talking through some of these pedagogical questions about climate mainstreaming, how we might embed climate considerations and subject intended learning outcomes, how we can include it in assessment tasks, etc. as well. So stay tuned. So one of the learnings from our project was that the development of these open educational resources are most successful when it's part of a broader project that generates both interest in and an audience for the resource. And there's ongoing work that's needed to drive take-up of the resource, both by individual academics, but also through institutional centering of climate change considerations in Australian law degrees. We've had a couple of universities that have really taken this up and have done it at an institutional centralised level at Bond University and Queensland University of Technology, for example, but at other universities, it's more individual academics doing sort of supplementing sort of work. But I'm really excited about sort of promoting the model that we've adopted to do this work to colleagues around the world. And so I'm really delighted to speak to you, and I hope that some of what I've said has relevance for your own context, and maybe some of our strategies might also be something that's applicable in your context as well. So just a couple of acknowledgements that I've drawn on some of the work that were published, also documenting the work that we've been doing that you can access there as well. So thank you very much for listening. Should we, are there any questions or comments?
I think there was a mic issue there. So yeah, we open to questions.
Yes, yes. So, ma'am, what are some practical changes?
Meanwhile, any of you have a question that you would like to raise?
So, what are some practical changes law schools can make in the curriculum to produce climate conscious lawyers? Ma'am, can you explain with respect to that? Am I audible?
Sure. So I think a good way to start is to think about one or two subjects where you think these questions of climate change are most relevant to those subjects. So it might be, in a subject on constitutional law or property law or human rights law or company law, for example. And then, depending on if there are any climate litigation cases that really engage the law in that area, teaching those cases as part of the subject. It might be about raising particular discussion questions in class. So we might have a principle of, tort law, duty of care. How might this apply in a climate context? Raising those questions. So there might be a case where you don't yet have a clear judicial pronouncement of what the law would be, but raising that as something for students to think about, or how could we formulate an argument about climate change using the doctrine that we have just learned, for example. In some cases, it might be something as simple as bringing a newspaper article about a contemporary legal issue that engages climate change. So there might have been a recent disaster and someone might be suing a company. So what is a legal issue? Or houses might have been destroyed. So what are the insurance implications, etc. So I think there's a lot to be said for bringing in these sort of, and I think that's great in legal teaching generally, to bring in contemporary examples about how that area of law really relates to ongoing challenges and disputes in society. So I think there's a number of different strategies that can be adopted. It's easiest, of course, where you have, cases that are directly on point that can be then taught, or if you have legislation that's directly on point. But I think there's also ways of bringing it into discussion and questions as hypotheticals. What might happen in this scenario? Asking students to debate, or, as we often do with hypotheticals, to apply the law to a set of hypothetical facts that could involve climate challenges, or bringing these sort of news and articles into the classroom.
Julia, just so that if I can ask a supplementary question.
Yeah, of
Uh,
course.
when you were offering this to the students, just adding on to what I was asking about, was there in more than a resilience? What were the shift that they had to adopt in order to accommodate this kind of change from a student perspective, if you could?
Yeah, sure. So some of the main resistance that we've had for this sort of work has come more from teachers rather than students. And some of the main concerns from teachers have been the curriculum is already incredibly full. We hardly get through everything we need to teach in a semester anyway. How can we cram anything else in? Or we're so overworked and we're so busy, how can we possibly fit any more in? And so to those two concerns, we sort of say, well, particularly about the work concern, that's why we're trying to create these resources to make it as easy as possible for lecturers to do this without having to do their own research, that we provide them the resources that make it easy to do this work, or as much as possible. And that also, by having a community practice, you can share experiences, share strategies that have worked, etc., that no one has to reinvent the wheel from scratch themselves. In terms of the putting, there's already so much in the curriculum, would say too that it's not necessarily about teaching more stuff, but bringing climate lens to bear on the things that you're already teaching. You're already going to be teaching directors' duties in a company law class. So then it'd be putting that lens on, what does that mean in the context of climate change? What are directors' duties in relation to climate change? In tort law, you're already going to teach duty of care. But again, you could then put a climate lens on and say, how would this apply? In terms of, who owes who a duty of care in a climate context, for example. In terms of students, we haven't had much pushback from students. I imagine some of the main challenges would really be the students who just want to get their degree and get the things that they think they have to get their job and get out of here and be successful. And I think that's why I really started this question of professional competencies and professional expectations, that we really say to students then too, that this is increasingly what you need to know, not as an additional extra, but to be a good lawyer, that you are letting your client down if you are not thinking about these facts. And that relates whether you're working in sort of public interest law or whether you're working in commercial law. And I think increasingly in the commercial law space as well. So, that's why I sort of really try and bring it back to those questions of professional competencies. And similarly, I think there's some resistance from some academics and from some students that this is sort of pushing an ideological agenda. And to that, I sort of say too, look, the fact that climate change is happening is not really a matter of debate. It's a scientific reality. There are, however, a lot of questions, deeply political questions about how we as a society respond to the challenge of climate change and the different policy solutions that we can put in place to address climate change. And again, these are precisely the things that we should be talking around in a law school classroom. Should we have taxes? Should we have emissions trading schemes? What does that mean in terms of who bears the liability, who bears the cost? How does this distribute? What are the equitable implications of these? These are all very live legal questions that students should be debating. So I'd be saying we're not trying to push a particular response in relation to climate change, but just that climate change is a reality. And you need to think about these questions of how the law should respond, which is still quite open, and think about them and form a view on them. And there's space for a lot of debate on those questions too. So it's not like just pushing one agenda, but it's really about raising a set of questions that really then forces students to think with the material. And thus, I think a lot of this work on climate mainstreaming really helps us do some of the work that we already want to do, which is asking students to think about how the law applies in practice and to think about the law not just as a question of law on the books, but also how law applies in society. And I think this climate embedding really helps us do some of that work as well.
So we shall wrap up for now. Thank you, Julia, for your insightful and thought-provoking presentation. Today's discussion has highlighted the crucial role that legal professionals play in addressing climate change and steps we must take to integrate climate consciousness into legal education. Some key reflections from today's session include the need for law schools to embed climate law into their co-curriculum, the importance of interdisciplinary language, interdisciplinary knowledge, and legal strategies to tackle climate change challenges. And I also want to thank our audience. If you would like to explore this topic further, I would encourage you to visit climateconsciouslawyers.com to learn more about Julia's ongoing work in this space. Once again, I'm Parvati PB, Assistant Professor of Law at Government Law College, Ernakulam, and it has been a pleasure moderating this session. Thank you, Julia, for sharing your expertise with us today. We truly appreciate your time and contributions. And with that, we conclude this session, wishing you all a great day ahead. Thank you.
Thank you.
Thank you so much for having me, and all the best for your remaining workshop and discussions.
Thank you so much, Julia. See you.